it would go on forever and not come up with particular and specific solutions to real problems. The terms of reference are in 10 paragraphs. The principal term of reference, paragraph 1, asks the Royal Commissioner to examine failings in the child protection and youth detention systems administered by the Government of the Northern Territory. The scope of the inquiry will commence with the period during which the Northern Territory's Youth Justice Act has been in operation. That Act has been in operation since 2006. The Royal Commissioner is asked to examine the treatment of children and young persons detained at all youth detention facilities administered by the Northern Territory Government, including, but of course not limited, as the Prime Minister has said, to the Dondale Youth Detention Centre, to consider whether any such treatment might have been a breach of any Commonwealth or Northern Territory law, a breach of the Northern Territory's duty of care or other relevant duty, a breach of human rights obligations adopted by Australia or the Northern Territory, or a breach of any relevant policy, rule, procedure, standard or management practice applicable to those facilities. We've asked the Royal Commissioner to examine what, if any, oversight mechanisms and safeguards were in place, and if so, why they failed. We've asked him to inquire into whether there were any deficiencies of the organisational culture, structure and management in the Northern Territory's youth detention facilities, and whether more should have been done by the Northern Territory Government to take appropriate measures to prevent the reoccurrence of appropriate treatment, and in particular, why the two reports of January 2015 and of August 2015, the latter of which looked specifically at the Dondale Centre, were not given effect to sufficiently or at all. We asked the Royal Commissioner to make recommendations about what measures should be adopted by the Northern Territory Government to prevent inappropriate treatment of children and young persons in the child protection and juvenile detention system in the future, and what improvements can be made to that system, including the identification of early intervention options and pathways for children at risk of antisocial behaviour. Finally, we asked the Royal Commissioner to consider the access by children and young persons detained in the juvenile detention network of the Northern Territory to appropriate medical care, including psychiatric care, and there is a general term of reference that gives the Royal Commissioner the capacity to examine any other matter relevant to the terms of reference. As I said in my introductory remarks, we believe that these terms of reference are both sufficiently focused but at the same time sufficiently broad that we'll get tangible outcomes from this inquiry which will see a measurable improvement in the delivery of these services by the Government of the Northern Territory. I want to thank two people in particular. I want to thank Mr Adam Giles, the Chief Minister of the Northern Territory, who has been, as I'm sure the Prime Minister would agree, extremely cooperative with the Commonwealth. Even though this is a Royal Commission or an inquiry into the operation of agencies and departments of his government and of previous Northern Territory governments, he could not have been readier to cooperate with the Commonwealth's initiative than he was. And I also want to thank the Royal Commissioner, Justice Brian Martin. To have a former Chief Justice of the Northern Territory, a former Commonwealth DPP, a former Justice of the Supreme Court of South Australia and Acting Justice of the Supreme Court of Western Australia, willing at very short notice to step into this role, has made the early arrangement of this Royal Commission possible. I want to thank Justice Martin very much for being so willing to serve, and can I invite him to say a few words, and he's indicated that he would be prepared to take your questions. Justice Martin.
Thank you, Prime Minister and Mr Attorney. Well, it has happened very quickly. I feel privileged to have been asked to undertake this important task. There is a lot of work ahead of us. I'm going to try and hold a directions hearing to get the thing rolling on the 6th of September 2016, with a view to commencing hearings perhaps in early October, but you'll appreciate that there's much to be done in the meantime. As has been mentioned, a number of people and organisations have already indicated their willingness to assist and their desire to put information before this commission. So we look forward to hearing from anyone who believes that they have useful information that can assist. So as I said, it's a large task, but it is a vital task. And we look forward to it, and there will be a website and a number available immediately through which inquiries can be made. Now, I'm perfectly happy to answer questions.
I might ask you a question first, Prime Minister, and Commissioner, please feel free to answer.
Whoops. Yes.
Given 9 out of 10 children in the Northern Territory's youth detention system are Indigenous, and I haven't heard the word racism once for the terms of reference, are you all satisfied racism doesn't play a role here?
Look, I think it's appropriate for me to answer that question. Whether racism does or doesn't play a role will be part of the inquiry. This is about child protection systems. It's about the culture. You'll notice that the terms of reference include questions about the culture within the system. And naturally, if people believe that racism plays a role, then that's going to be the subject of evidence before the Commission. So it will be not appropriate at this time to make any predictions about what does or doesn't play a role within the system in the Northern Territory.
Will there be scope for the Royal Commission to call either members of the Northern Territory Government or indeed members of the Federal Government to appear before it?
There's certainly that scope.
As we know, most of this material, although not the footage, was known last year, and there were the 2 reports that the Attorney-General referred to. Indigenous Affairs has now been under the Prime Minister's Department for 3 years. Have you made any inquiries as to whether any of the bureaucrats in the Prime Minister's Department read and absorbed these reports, especially the August 2015 one?
All of these matters will be considered by the Royal Commission, and I will certainly examine the extent to which officers in the Federal Department of Indigenous Affairs were aware of these matters.
The terms of reference talk about measures to be adopted by the Northern Territory. Why doesn't it talk about measures that the Federal Government can also adopt? Well,
the youth detention and child protection services in the Northern Territory are administered by the Northern Territory Government.
Aren't there broader issues involved in this that the Federal Government could intervene in?
Well, this is an inquiry into the child protection and youth detention systems of the Northern Territory Government. Again, I've said this before, and in the course of media discussions, in fact, earlier today. A Royal Commission is most effective when it has clear terms of reference that enable the Royal Commissioner, in this case Mr Martin, to get on with the job and focus on the critical questions and issues at hand. There are a lot of other associated issues which will be debated, discussed, a huge number of issues that I've just talked about with, as indeed George has, with Indigenous leaders just over the last few days, and a lot of related issues. But in terms of this fact-finding exercise, what we have is some parameters, and I think, I'd have to say, I think the attorney has found a good medium between terms of reference that are highly focused and limited, but have enough breadth to enable the Royal Commissioner to look into associated areas without being so amorphous that the inquiry would be endless.
Just to clarify, will the Commission have the ability to look into other reports, other recommendations in the time going back to 2005, including the Little Children Are Sacred report, the Bath Commission of Inquiry, and also the report done by Jodine Carney?
Yes.
Do you have a time frame in mind? I know the Prime Minister had said perhaps reporting as early as next year. Is that enough time for you? Would that be too rushed?
Well, we'll find out, won't we? The letters patent say the 31st of March. That is tight when one looks at the breadth of the terms of reference, but given some hard work hopefully will meet it, but I'm sure that if I need extra time, it will be given to me.
What did Cabinet decide about Kevin Rudd?
Can we just deal with finish questions?
Do you think it could be appropriate that we see compensation to the victims of this abuse?
Look, I'm not going to give an opinion on that.
As an Australian and as a father, you watched this and you were shocked. Do you think that there should be punishment?
Well, look, there are avenues for seeking compensation that exist within the law as it stands, and these are matters that the Commissioner, as the Commissioner is pointing out, he is directed to make any recommendations arising out of the inquiries he considers appropriate. So he's in a position to make recommendations of that kind, but I'm not going to give, you're asking me in effect to preempt the conclusions of the Royal Commission before it has actually started even having a directions hearing, let alone hearing evidence.
Prime Minister, did the Chief Minister agree with the terms of reference? Have you discussed them with him?
Yes, we have. I think George can confirm that. Yeah.
Yes, well, the Prime Minister and I have had a number of discussions with the Chief Minister. I've discussed, I think I can say that we finalised these terms of reference with him over last night. There have been earlier discussions as well. These terms of reference are the joint work of the Commonwealth and the Northern Territory, and as the Prime Minister indicated, we expect that a commission in terms identical to the letters patent will be issued by the Northern Territory Government under the Northern Territory Inquiries Act.
So what's your message of reassurance to the Indigenous community in the Northern Territory? There's been a lot of commentary in the last few days, people urging the government, the federal government, not to involve the Northern Territory government in the administration or setting up the terms of reference. Instead, you've congratulated Adam Giles on his performance in that process, or your attorney has. So what's your message of reassurance to them that this inquiry isn't compromised from the beginning?
The Commissioner is completely independent of any government, and is directed, indeed bound, to conduct a thorough investigation within, obviously, the framework of the terms of reference. Mr. Martin was served as the Chief Justice of the Northern Territory with great distinction, and developed and demonstrated a very keen understanding of Indigenous culture and indeed the interaction between Indigenous culture and our legal system. I don't know if you want to say some more about that.
No, I don't think so. I think the Prime Minister said it. My job is to look at the evidence and assess it impartially and objectively.
Yeah, that was never in doubt. I was really asking a question about what the message to those people was. They feel incredly let down by public officials.
But the message is that as soon as these matters as soon as we became aware of them, as soon as I became aware of them, I took steps to establish a Royal Commission within hours, in fact, and we have now, a few days later, we have the terms of reference agreed, the letters patent issued, the Royal Commissioner appointed, a man of immense legal expertise, immense experience, a distinguished judge who has also a very keen understanding of the special challenges and circumstances in the Northern Territory. So Mr. Martin is extremely well qualified for this task. Well, hang on, just perhaps you, sir, and then we'll have one more. Yeah.
Given you've spent so much time in the Northern Territory in this justice space, are you concerned there may be any perception of conflict of interest?
I don't think so. I can't see how that would arise. There's never been any suggestion that this sort of treatment was brought to my attention or the attention of other Supreme Court judges. I don't see that at all. I see the advantages of a knowledge of the territory. And to answer the question earlier, those who are disillusioned, I encourage to come forward. There's their way in to make their views and their concerns known so that they can be properly assessed and addressed as best we can.
Just in addition, so no concerns that you might have been involved in a judicial sense with any of these young people either?
Oh, look, I couldn't guarantee that I haven't sentenced a young person. You'll appreciate the vast majority of sentencing is done in the children's court or the youth court. I can't say that I won't necessarily have sentenced someone for an offence, but never in my experience when a child offender has come before the court, has anyone stood up and said that child offender has been mistreated in a significant way within the system. There are always, from time to time, complaints that someone might be victimised because of the nature of the offence they've committed. So those sort of things are said. But never has anyone come forward and said, look, while in custody, this child was tear-gassed, or this child was hooded, or there was some mistreatment of the child. So the mere fact that I might have sentenced someone, I don't see as a problem at all.